My final two cases involve challenges to eminent domain takings pursuant to General Laws, Chapter 79. In the first case, Abuzahra versus City of Cambridge, the Supreme Judicial Court is being asked by the City of Cambridge to determine if a property owner whose property was seized by the city in an eminent domain proceeding under General Laws, Chapter 79, must choose between accepting the so-called pro tanto award if the city determined the property was worth, or challenging the validity of the eminent domain taking. The property owner, on the other hand, argues that the city must immediately pay him the full amount of the pro tanto payment, along with interest, because General Laws, Chapter 79, as it is currently written, does not condition his acceptance of the pro tanto payment on waiving the right to challenge the city's actions in taking the property. Now, this case began in 2016 with the city's actions challenging the property owner's blighted 0.65 acre parcel in the Central Square neighborhood of the city of Cambridge. After the city's efforts failed to convince the property owner to improve his property, the city council voted to take it by eminent domain, demolish the derelict building, and put up affordable housing. The city set aside the amount of $3.7 million for what it claimed was the property's fair market or pro tanto value. The city established its determination of value without consulting with the property owner. The city, however, refused to issue the check to the property owner, at first because there was a dispute in separate litigation about record ownership of the property, and even after title was established, the city still refused to pay on the basis that Abuzahra was suing the city to get the property back. At the Superior Court, the plaintiff sued the city seeking, one, invalidation of the city's 2016 taking, and two, an assessment of temporary damages, and if the taking was found to be valid, a determination of permanent damages. The city stated it would pay to the property owner the pro tanto amount. Now, after the property owner filed a motion to compel payment of the pro tanto in May of 2019, a Superior Court judge denied the motion, stating in his opinion that it would be, quote, somewhat incongruous, unquote, for the property owner to demand both the payment of the pro tanto award and the return of his property. The property owner then filed an interlocutory appeal with a single justice of the appeals court over the Superior Court's judge rulings with regard to the pro tanto award. The single justice reversed the order, stating that there is no language in Chapter 79 that provides an exception for the payment of the pro tanto award. The city then appealed to the full appeals court, and the Supreme Judicial Court took the matter up on its own. The SJC began its opinion by analyzing the legislative history of General Laws, Chapter 79, the eminent domain statute. Next slide, please. The SJC highlighted from case law interpreting the eminent domain statute that, quote, the taking of land from a private owner against his will for public use under eminent domain is an exercise of one of the highest powers of government, unquote. Due to such an overwhelming exercise of the powers of government, the SJC determined that utilization of the eminent domain must be strictly construed to assure that the rights of the property owner are respected. After review of General Laws, Chapter 79, the SJC stated that the plain meaning of the statute compels a conclusion that under Chapter 79, a property owner may accept a pro tanto payment and challenge the validity of the underlying taking. The statute, by its terms, also requires that the taking authority, in this case the city, must offer the pro tanto award to the property owner within 60 days of the recording of the order of taking, and shall be made immediately available to all persons so entitled according to the statute. The SJC also reviewed the legislative history of General Laws, Chapter 79, and recognized that the government's taking of a property by eminent domain may impose sudden and heavy financial burdens on property owners, and the challenges immediately faced by property owners seeking to keep the properties. Therefore, the city ordered, the SJC ordered the city to pay the pro tanto award with interest prior to the resolution of the property owner's challenges to the eminent domain taking under General Laws, Chapter 79.